But I want to talk about how divorce and marital statuses can really hurt a closing if you guys don't do your homework before the week of closing. All right? So here's the general rule. In North Carolina, if a person is married, the spouse must sign something. I think that's just a general, and we'll talk about exactly what they got to sign in a minute. But in North Carolina, if a person is married, their spouse has got to sign something. That's whether the spouse is on the deed or not, and whether the spouse is going to be borrowing money or not. The spouse must sign something.
Just to sell it.
Or buy it. Yeah. Yeah, and I'll talk about an exception to that in a minute, okay?
Yeah. A lot of questions.
Okay? So the spouse must sign something. Just remember that rule, okay? And there's an exception that's starting to form in the law, and we're looking into as a firm as well. But with our firm, we're requiring the spouse to sign everything right now, okay? All right, so how do you make it so that this doesn't derail your closing? So just 5 tips from me. I think the first thing is listen for buzzwords. When you're doing your initial talks with your potential clients, listen for things like, my wife and I are separated. If you hear that, like big flashing strobe lights in your brain, this could screw this thing up, all right? All right, so my wife and I are separated. Things like, we have a separation agreement. Things like, this will be in my own name, or things like, she's on the deed, but we're getting divorced, so it doesn't matter. Listen for buzzwords like that let you know this is going to get weird, okay? That's what you want to listen for, okay? So listen to buzzwords. Oh, another one that I've heard is, we haven't seen each other in 3 years. You know? We had one that came to the closing table a couple of years ago, and for whatever reason, the first time it was supposed to close, it got delayed, and it's a couple weeks later, and this dude met a girl on Tinder and got married in 2 weeks and didn't tell anybody about it. He sat down with me at the table. We signed everything, and then he said, "Okay, I'm going on my honeymoon now." And I'm like, what? And so we had to send the whole thing back into underwriting, shred everything. And so listen for buzzwords. Tell your clients not to get married before closing, if they can hold off, you know? So listen for buzzwords, like really. What does it mean to be divorced in North Carolina? Like, what is that? They say I'm divorced, but what is it legally? There must be a signed piece of paper by a judge on file with the courthouse. A separation agreement is not divorce. That's them signing something before they're divorced that says how they want the judge to treat their divorce. But that's not a divorce. That's a separation agreement. So a divorce where you don't have to worry about the spouse, they are no longer married, is a judge having signed off on an order that says you're divorced, and it's filed with the courthouse. That's what a divorce is. That makes sense to everybody? Any questions so far? None so far. All right. Tip number 2. The spouse must sign something that is recorded. So the spouse has got to sign something that is recorded. That means it's got to be on file at the courthouse. So they say, I've got a separation agreement. Now a separation agreement is like a 20-page piece of paper, right? And the separation agreement may deal with this real estate, but I've got to file that with the courthouse. People don't want their separation agreements a public record at the courthouse usually. Sometimes we have filed separation agreements, but usually not. So if they say I've got a separation agreement, you can be, okay, cool, that will work, but we got to file it. There are other options. And so let me tell you sort of 4 options that we can use to deal away with the spousal interest. Okay? Is everybody with me so far? We're good? We're good. Okay. So there's two kinds of sort of spousal interest. There is the kind where the spouse is on the deed. When they always say that spouse is titled. That's easy. Okay? See, we're not going to talk about that. The other kind of scenario is the one where the spouse is not on the deed. So I, Jason, own my house and Kelly's not on the deed, okay?
Why? Because if you got.
Because I don't trust her. I work for my money. She watches my, she doesn't do nothing. She watches my
Does that normally happen because they
Oh, yeah.
owned the
It
house
happens
before they got
all
married?
the time.
Yeah, we
That's
have a
what
house
my
like that
experience.
my
Yeah.
husband owned before we got married. It's a
Yeah.
rental property, and I'm not on the deed, but I found out in real estate school that I own the thing, or I'm interested.
So listen, the other stuff we were talking about, the HOA stuff, that's like going to be a rare thing. A firm y'all size will deal with it once in the next year maybe. This stuff, every one of you will deal with probably in the next year, okay? And so, yeah, so again, two kinds of scenarios. Spouse is on the deed, that's normal, right? Spouse is not on the deed. I own the house by myself, but I'm married to Kelly. You've heard buzzwords of me saying, yeah, but she doesn't care. You know, so there's 4 ways that we can deal with Kelly's spousal interest. Kelly has a say. Let me just go, like, give you 20 seconds of how, like, ridiculous this is. This is Kelly's spousal interest. This is what she could do. If I die, first, she would go into mourning for about a year and wear all black, and all that. Yeah, that's what's gonna happen. But in my will, if I leave all my property to my kids and cut Kelly out, right? Because I don't trust her again. You understand? So she's wearing all black and hadn't got any property from me. Kelly can disrupt my will and claim a 30% share in my real estate. It's called the widow's share. And so that's a spousal interest.
That's
so,
my payment for being married to you.
That's right.
She get more.
So.
And it should be more.
I'm not sure how to take that.
It should be more.
And so that's what we're trying to avoid, is that spousal interest. I sell property to somebody, I then die, and Kelly comes back and calls back that property that got sold with her spousal interest, okay? So there are 4 ways to deal with the spousal interest. 4 pieces of paper. Remember, the spouse in a non-title situation, Kelly's not on the deed, has got to sign something that is recorded. Okay, 4 things that can be done. The first is what we've already talked about, a separation agreement with free trader language in it. Okay, what free trader language is, it says, I, Kelly, know I have a right in Jason's house, but I completely give it up. I give away my widow's share, okay? And then that gets recorded. As we've discussed, we don't like to record separation agreements because they've got things like alimony in it. Kelly could have shook me down for, you know, a lot of money in alimony. People don't want that stuff on public record. We can file that. The best option is what's called just a free trader, which is just a 1-page piece of paper that just says in a paragraph, I, Kelly, give up all my rights in Jason's real estate. And it gets recorded and you're done. And then I can sell all of my real estate that she's not on to anybody without her interference. Okay?
Is there a difference between that and a quitclaim deed?
Yes.
Or is that okay?
Very much so.
Okay.
So a quitclaim deed, and sometimes lawyers who don't know what they're doing will have Kelly do a quitclaim deed of that she's not even on the title on, of my house to me. And she's saying, I give Jason's house to Jason. Well, she didn't even own it, first of all. But the quitclaim deed without free trader language in it that says, I give up my widow's share, does not work. And so when you see those quitclaim deeds come along and they don't have that, and 99.9% of them do not, then it's completely ineffective.
It's more like when the like people inherit the stuff, and is it the title people that go around and have them sign that paper that says if they have any interest, they'll let go of it.
That's probably what
thing.
happens there. Yeah. So I inherit my dad's house. Kelly doesn't inherit it because she's the daughter-in-law, right? Kelly still has her widow's share in my house I received from my father. She will have to sign off on it.
Yeah.
Much time as possible to get this stuff in. And be thinking about this. I would recommend it. So what I mean by that, flag it for your attorney. A couple things. 1, just tell them on the phone. 2, every attorney has information forms they send out. Make sure on the information forms you list it again, okay? That there are marital issues. And then again, as Bonnie just said, in that initial interview, just ask the question, are you married? Okay? Just ask, are you married? And I think that'll help a lot. So flag it for your attorney, really communicate with your attorney. And then finally, number 5. We've hit on this a little bit. We've been talking about non-titled situations. I own my house by myself, my wife does not own it. If you're selling or buying real estate where both spouses are owning, obviously then both spouses have got to sign, okay? And so you were just asking about one where they're getting divorced, he wants to quit claim, which has to happen, he's got to get rid of his title interest, but then he also has to get rid of his widow's share interest as well. So I know that's sort of a distinction, a tough distinction there, but I hope I've helped you understand it a little better. I got one more quick thing, but first, what questions do you have?
I have one that still making me lose my mind. Both are on the deed. They got divorced, and now one of them has died.
Okay.
The one who lived in the house has died.
Okay.
The ex-wife left, but now she wants to sell.
All right, so first of all, you said divorce. So has a judge signed, let's review what we've learned. Has a judge signed something somewhere?
Yeah, they got divorced in 2009.
So they're no longer married. So when two spouses own real estate together and they're married in North Carolina and one dies, the law says that the property automatically, without a will, goes to the other spouse. It's called tenancy by the entirety. You probably heard of that, right? That's why it's good. It really is a good idea to have your property in your spouse's name. Okay? But they're no longer married. So when they stop being married, what was a tenancy by the entirety is converted into what's called a tenancy in common.
Yes.
Hey, you knew that. And so now it's like two brothers or brother and sister own the property. When one of them dies, then the property goes into that dead person's estate. And whoever that person's will says owns the property, owns the property. So wife then, in your scenario, doesn't own 100%. She owns 50%, and then the other 50% is held by the estate of the dead ex-husband.
Yep, his kids.
Are they her kids too?
No.
Oh, that's a problem. Okay.
Yeah. There's
are
no
his
love
kids
there.
married?
There's no love there.
There's
Yeah,
no-
exactly.
There's no love there.
Then you're getting into multiple layers of issues. So does that answer that?
Yeah. And, well, because you and I have actually talked about this one before, I'm just sharing as information. And then taxes and insurance. From when they got divorced, she's still responsible for half, right?
Yeah, legally they're both responsible for half, both ownership.
So from
interest.
2009 to whenever they sell it.
Right. Right, but that's something a closing attorney can't enforce. You know, if the husband, the ex-husband's kids are like, we're not paying that, you've lived there the whole time. And that's what they're gonna say.
Well, he's lived there, the dad lived there.
Okay, so if wife says, I'm not paying that, he lived there the whole time. Well, legally she is required to pay it. You're not gonna sue over that. You're gonna be stuck at a closing table negotiating that between your sellers, trying to get them to figure that out.
Yes, that's why we have
there's a difference between what the law says should happen and when you're at a closing table, what actually happens, because you're not gonna sue on this stuff. You're not gonna go to a judge and get him to enforce the law. So
They hate each other, so they
negotiation.
might.
Okay, any other questions
That's all.
for my last thing?
I had one about the reach of the widow's
Yep.
shares. So I'm trying to imagine a scenario where, like, we're buying a property and the guy's like, yeah, I inherited this from my dead father. I just want to sell it. And then your guy buys it, and then all of a sudden the estranged wife of the dead guy comes up years later. Nobody's heard from her forever. Does she have?
I'm not
say
sure
in
what
that?
the statute of limitations is on a widow share.
Yeah.
I don't know the answer to that. I know it's enough that we've got to get the wives to sign off on it. Now, if the I don't know the answer to that.
I learned, you're the attorney, but I remember from real estate class, I think what we were told was that as long as the spouse is living, you have that marital interest in the property. And then when you die, then it will go to whoever inherited the, that's what we were taught in real
Yeah,
estate class.
and that's when they were talking
But I don't
about
know.
how you have to be careful, because if you sell it, you have to make sure that everybody that's touched in that chain
Yep.
has to sign off on
Yeah.
that.
I'm sitting there thinking, what if she's in Cabo this whole time, and
She
then
still owns
the
it
son,
from Cabo.
the son sells it to my
Get to close it,
client,
thank you.
and then the widow shows up, she's like, nah.
Yeah, there's some. I'm not sure how long that lasts. So here's my last.
Title insurance cover that? If she comes
No,
back
title
in
insurance
10 years?
specifically excludes widow shares. It's on the lawyer. The lawyer's malpractice will cover it. So this is why lawyers, we're sticklers over this stuff, because I'm not gonna be,
I don't blame you.
you know,
Why do they tell us 1 to buy, 2 to sell in school then, and you're saying?
that's what I'm saying. One spouse can buy it, but
But you
then
said
both
they
spouses
both
have
have
to
to
sign to
sign.
sell. That's
Oh.
why one to buy, 2 to sell.
But when, like, we're married and he went and bought a house.
Yep,
I don't
one to
have
buy.
to be there and I don't have to
Right.
sign it.
That's
Yeah,
one to
yeah,
buy.
yeah.
Okay.
But you still have
Yeah.
to
You got it, and
Right, you
but then when he sells
you
it,
still
Yeah,
own
I'm in
it.
there, yeah.
one to buy, 2 to sell.
But now you need my.
All right, last thing. So there is, for our firm anyway, we're researching this hard. An emerging thought. We have historically, as a law firm, when a husband buys a house, it's just him on the deed, it's just him on the loan, and he's married, we have required the wife to still sign the deed of trust, because that is she has an ownership interest, so her ownership interest as a widow's share needs to be subject to the deed of trust. So we've historically required that. We're now being told by certain title insurance companies that you don't have to do that anymore. It's a purchase money deed of trust transaction where when you're buying a house, not refinancing, getting a second mortgage, when you're buying a house, there may be a very narrow exception in the law that doesn't require the non-titled spouse to sign away their widow's share and still subject the deed of trust to the husband and wife's ownership. Okay, we're looking into that right now. I told our folks, our general policy is spouses have got to sign, but we might have some loophole room we're working out.